It's a ruling that activists fear will blur the lines around consent and be a damaging step backwards for India's rape victims. As a Delhi High Court judge has ruled that no doesn't necessarily mean no. Last year, Bollywood filmmaker Mahmood Farooqi was sentenced to 7 years in prison for raping an American student. The woman told the court Farooqi forced himself on her, and while she repeatedly said no, after a while she stopped resisting, fearing she could be severely harmed. But on appeal, a judge ruled that there was no evidence the incident happened, or that if it did, that it happened without consent. The judge's ruling stated that in a case where the parties are well educated and known to each other, it would be really difficult to decipher whether little or no resistance and a feeble no was actually a denial of consent. India is struggling to deal with its high levels of sexual violence, street harassment and patriarchal attitudes towards sex. This ruling has raised fears that the gains made in recent years will be lost. In 2012, the gang rape and murder of a woman on a bus sparked mass protest. The public outcry led to a tightening of India's rape laws, including harsher punishments for rapists, expanding the definition of rape, and adding that the absence of a physical struggle doesn't equal consent. Since then, more and more women have been reporting rapes. In 2012, there were close to 25,000 reported cases. In 2015, there were close to 35,000. That's around 94 women a day. And of these, 95% were committed by someone known to the victim. But there's fears this ruling will make it harder to convict rapists and reinforce the belief that it's a woman's responsibility to prevent themselves being assaulted.
In our country, if a daughter is raped, it is often said she has brought shame to herself. People label her impure and unworthy of getting married. The whole family is stigmatized by society. We are so sick from within.
But critics to the recent changes say the increase in reported rapes is being driven by false accusations. They argue that men are at risk of being blackmailed or having rape accusations brought against them as punishment or revenge. And in cases like Farooqi's, they need to be given the benefit of the doubt. Will this dilution of the definition of consent lead to fewer victims speaking out in India, or prevent them from getting justice when they do? Yvette McCullough, The Newsmakers.
Well, joining me now from New Delhi is Nandita Rao. She's a lawyer at the Delhi High Court, where the ruling in Farooqi's case was made. And also coming to us from India's capital is Juma Sen. She's an assistant professor at Jindal Global Law School. I thank you both for joining us. Nandita Rao, let me begin with you. A feeble no doesn't mean no, according to the ruling. Do you believe that Farooqi's acquittal was just?
I think the feeble no portion was not really the finding of the court. It is what we call an obiter. It was a general observation made in the context of the complainant's own email, in which she says, at the end, I consented. So the judge has in fact said that, you know, sometimes during the act of, during a sexual act, from kissing to anything else, one may change one's mind at numerous moments. So that is the right of the victim or the complainant, and it is only the ultimate consent which is given which will count. Whereas eventually the judge gave the benefit of doubt to the accused because the WhatsApps sent by the complainant, contemporaneous, that means minutes after the alleged offense, she makes no mention of this offense to her friend, and there are 10 or 15 WhatsApps that go back and forth. She says that there are 2 people present at the house where she alleges this incident occurred. Independent mobile evidence shows that a call made by the complainant and the accused together to a friend and the entry of a third friend into the house, there was only 2 minutes when both of them were alone. So the judge, taking all this evidence into effect, and further the fact that the FIR was registered 5 months after the incident, and the first email in which she calls it a sexual assault is only 3 weeks later. And subsequent to the incident, she actually writes to the accused saying that she loves him, admires him, and is attracted to him. So the judge has actually said that I don't believe she's lying, but memory has a way of being inventive and selective. And from all the independent evidence, I must give the benefit of doubt to the accused that it is possible this incident never occurred.
Okay, so let me then...
I think that on the balance of evidence, it is not an unjust decision.
Okay, fair enough. So you laid it out, right? Nandita Rao laid it out, Juma Sen. Are you convinced by any of that? She's laid out the other side of the story why the man deserves the benefit of the doubt. Tell me why you disagree.
Not at all. First, let me affirm very confidently that what the court says, when the court says that this is a matter of feeble, no, the court is not stating as an obiter. The court is, it's laid down in para 77 and paragraph 78 of the judgment. It's laying down why a feeble no may not mean a no, why it may mean a yes. Further, in para 96 of the judgment, the court actually holds, after going through WhatsApp messages and whatever discrepancies, apparent and alleged discrepancies between the versions of the accused and the complainant surface, the court goes through all of that, and in para 96, after going through all of that, the court records that the testimony of the complainant is of sterling quality. So there is no way the court is discounting the testimony of the prosecutrix. There is no way the court is finding anything wrong in the findings of the trial court. The court is actually upholding everything that has been said by the trial court. It finds the testimony of the prosecutrix to be of sterling quality, and nonetheless, it holds that in spite of the testimony of the prosecutrix being of sterling quality, it needs to create an artificial distinction, an artificial classification between different kinds of victims, which has no foundation in law, which has no foundation even in the facts of the case, because the consent that has been provided by the consent which is the subject of dispute here. The accused states that in the case of the accused in the trial court there was no act having taken place. So the question of consent was absolutely immaterial.
Let me come
in. And in the High Court, there is a completely... Let me just finish it. I'm sorry. In the High Court, there is a completely contradictory plea has been taken by the accused, and it has been urged that there was a consensual relationship, and on the basis of this contradictory plea, this feeble consent, this doctrine of feeble no has suddenly emerged, and it has absolutely no basis in law. It has absolutely no basis in the facts of the case. Because if you look at the para 77, in page 77 of the trial court order, and which has also been recorded by the High Court as well, the testimony of the prosecutrix, the FIR, the recorded, the statement under 164 of the Criminal Procedure Code of Criminal Procedure has been. It has been consistent, and it goes on to show that it was not a case of feeble no.
Because in the next minute, what I'm going to do is I'm going to put this individual case away and ask broader questions. But I want to ask Nandita one final specific question related to this.
I just want to say one thing on this individual case. There is no doctrine of feeble no. There is no such doctrine propounded except in the imagination.
Nandita, if I could...
Para 78 of the judgment.
Yes.
Okay.
Para 78 of the judgment.
Let me come in for a second. I have one question for you, Nandita.
It is an obiter, a general
Yes, you made your point. You disagree on this legally. Both of you disagree on this. Okay, Nandita and Juma, if you give me a second, let's all take a breath.
That's ridiculous.
Juma, we're here. We're covering this for an international audience because we want to launch this into a bigger conversation, if it allow me. But Nandita, let me ask you, in general, do you agree that a prior sexual relation between two people does not mean that someone can't have been raped by one of the other people? Would you agree with that legally, Nandita, that rape could still occur even if there was a prior sexual relation?
Absolutely, absolutely, and that is what the Honorable Judge has observed, that it is not just whether the incident occurred. Second question is whether it was by consent or not. And the third question is that was the consent communicated? And he says, just because I kiss someone or I allow them to go that far does not mean that I cannot withdraw my consent after that. Until this judgment in India, we had a unique law which said that the Indian woman is so innocent and conservative, and our society is so conservative that just her word can be taken for conviction, because we are not corrupted by the promiscuous values of the Western world. So this judge has distanced himself from that thinking. He says, just because she's a Western woman, I will not say that she's prone to lying.
Okay,
but
so
he explains it.
So then
he says
let's take
all
that.
the independent
Certainly.
evidence
And
you
support Judge Kumar's.
So he's actually come a step forward.
Certainly. Okay, so you see it as a progressive ruling, right? Let me then ask you, Juma.
Yes,
why
it's
you
a
think
step forward. It's a very, very liberated judgment.
Okay, fair enough. Now let me ask the question to Juma. Juma, let's broaden this out. Tell me why you disagree and why you believe that when it comes to gender-based violence, in your opinion, why do you think the laws are in favor of the accused? Tell me why.
Well, I will slightly rephrase that. I think that the laws, I mean, post the 2013 amendment to the criminal law, the laws are fairly generous, barring obviously we have a marital rape exemption, which is atrocious. But barring that, the rape law, after the Verma Committee recommendations and after those recommendations having been incorporated into the statute, the laws are fairly balanced, I would say. However, there is an embedded patriarchy in our courtrooms at work, and one cannot deny it even after the 2013 amendments having taken place. As recent as 2017, there have been countless reports. There is one report which has been submitted by a lawyers collective. There is another recently released by another organization called Partners in Law and Development, and it goes on to show how biased our courts still are when it comes to the implementation of these laws.
So Juma, let me talk about law. Let me add a layer to law, right? Let me add culture. I want you both to listen to what Nobel laureate Kailash Satyarthi had to say about this. Have a little listen.
We are a great nation. We are the nation of saints, reformers, and people who inspired us. We are not going to allow the rapists and abusers to occupy this space. India must not be ashamed as the land of rapists and abusers. So we are all marching. This is the war on moral epidemic which is growing in our society.
I'm curious to know your thoughts on this, Nandita. And if you'd allow me to ask the question fully here. So you could have laws on the books, if you'd allow me to ask the question fully. You could have laws on the books that are fully fair, right? Absolutely. They're just. But what we have Kailash Satyarthi saying essentially is that there's a culture of rape. What we have Juma saying is that there's an embedded patriarchy. Is that true?
So I'll reply to your question with statistics. There is an embedded patriarchy all over the planet, not just in India. And there isn't a particular culture of rape in India which is more than in the United Kingdom or in the United States of America. So the statistics are this, that India has one of the lowest per capita rape statistics. Say for every 100,000 people, in the United States it's 66.5. In India it's 1.6. We have an 8% per capita rape statistic, which is one of the lowest in the world. Secondly, as far as convictions are concerned, say in the United Kingdom, for every case that is reported, the total cases that is reported, there is a 7% conviction rate. 30% of the cases are rejected by the prosecution.
If we could just focus on India.
I'm just telling you, in India, we have a 29% conviction rate.
And these are, and it's great relative to other countries.
There is patriarchy. But it is not peculiar to India.
Okay, let's stay within the borders, right?
And if
let's
we
move
compare
away from
it to other countries, I feel in India it's better placed.
We don't want to pick on India, but let's look within the borders. Let me give you another example, Nandita. One more example. Within the borders. Move away from Delhi. A Punjab and Haryana court order labeling a gang rape survivor as promiscuous and suspending the jail terms of the 3 perpetrators, right? So you had their jail terms suspended, and the Justice Mahesh Grover and Justice Raj Shekhar Atri said the woman had a promiscuous attitude and a voyeuristic mind. Surely, I mean, you defended the last judge. You won't defend these judges, would you?
No, I'm not defending. This is condemnable, but in response to that, I tell you, in the case of Strauss Khan in New York, a very empowered person who was accused of sexual assault by a person in the prosecution did not even put it forward because the prosecution said that the woman is not credible. She's a liar.
Do you know,
so
Nandita, I covered that as a journalist.
Yes, we live in a patriarchal society.
Nandita, I covered that as a journalist, and when I covered it as a journalist, the guest didn't say, but in India they're doing terrible things to women as well. We spoke about the issue at hand. I'm asking you, that Punjab and Haryana court order, do you agree that that was wrong? To call a woman promiscuous as a reason for suspending the sentences?
I condemn it.
Okay.
I condemn it.
Okay, great. Juma, is there anything that Nandita
condemn it.
Okay, certainly, and that's clear.
Being promiscuous does not mean that you can be raped.
Okay, is there anything that Nandita has said, Juma, that has convinced you that the issue is a bit more nuanced?
I just want to say one very quick thing.
Let's bring in Juma and then you can come in. Juma, anything Nandita has said from what you've heard in the past 15 minutes, that has convinced you that there's more nuance to this?
It hasn't convinced me. And as far as all these comparative analogies go, I think I would first clear and clean my own house before concentrating on my neighbor's house. So as far as rape cases and rape statistics goes, I'm not going into the conviction rate, etc. Because if you look at NCRB data, for example, there is data and there is interpretation of data. So that requires a lot more nuance, and that's only where the nuance factor comes in. But as far as the judgment, and I wanted to flag this out because she said she very vociferously argued that this is all of this feeble no means obiter, and this is not really what the judges say. And I think that's like, pardon my language, but I think that is completely absolutely bollocks. Because if you look at the entire judgment, if you take a reading of the entire judgment, and if you look at the last 2 or 3 paragraphs, where suddenly the judge comes to a conclusion that there is a doubt, there is a reasonable doubt, but before the judge concludes that there is a reasonable doubt, the preceding paragraphs have absolutely no bearing, no relationship to that conclusion. So what do you call that? So therefore that means that whatever the judge has argued before that, whatever the judge has reasoned rather before that, including paragraph 77, 78, 96, those are not merely
there are 10 paragraphs which reach to that reasoning.
As observations. No, 96. Please read 96. Please read 96. What does 96 say? 96 says that the testimony of the prosecutrix is of sterling quality.
Read the other 20
paragraphs. If there is no 100.
And
I have read the other 20 paragraphs where the judge. I have read the
how she loves.
Oh, I have read the. I have yes. I have read.
Can I come in?
No, and please read. Please read 96. Please read 77,
Ladies,
78, 46, 47, 48.
I have to come in because
please read these paragraphs and please let me.
Juma and Nandita.
And please let me speak.
Certainly. Hold on. Juma and Nandita. I think this conversation is unfinished, but we've pushed our time over the limit. I have to move on. I hope we can get you both on the program again in the not too distant future. But I thank you for coming on the Newsmakers and having this important conversation. Thank you very much.